Good morning, and thank you for joining me on the Path to Liberty. It's Monday, September 28th, 2020. And on this episode, I'm going to share with you some quick views from pretty prominent views on things like property rights, the division between state and federal power, resistance to unconstitutional acts, and more from original Supreme Court justices, those who were nominated by President George Washington. I've got 12 quotes from 4 of these justices, and I think they will show you just how far things have gone off the rails in modern times. First of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage, 10thamendmentcenter.com/path to liberty, all spelled out. That's where you can get everything you need to follow this show. All of the archives that we've done for over 2 years, individual episodes. I do have a lot of links to original source documents, other articles, other episodes, so you can read, watch, listen, and learn more on your own time. You can find all the platforms we're on. Live streaming video, Facebook, DLive, YouTube, Twitch, and Periscope, archive video channels, library, Brighteon, BitTube, and BitChute, plus all the podcast editions, iTunes, Spotify, Stitcher, iHeart, TuneIn, and the rest. We're on Amazon Music as well. You can find all of those platforms, all of the stuff, and even ways to support us like our membership program over at 10thamendmentcenter.com/path to liberty. And of course, going through all this not only tells you where you can find us if one of these platforms happen to kick us off, but it also gives us time to allow people to get notifications on the live platforms, and they can join us today. And I want to take a look at some of the people and say hi to the live chat over on YouTube. Lauren Smith, Tyler B., WC Blum from Ohio. I want to thank you for your support, WC, and of course everyone else. Andrew Green, Blue North Wind, good to see you. Liberty Howell, Benjamin Blondin, MRGF 78, Bill Brennan, Dennis Marburger, good to see you, buddy. Richard Kramer, good to see you. I haven't seen you here for a while. Thank you for being here. Dan Reed, and everyone else. I apologize if I miss anybody. You know, I should make a quick tip of the hat to Ron Paul here before getting into this, because if you may be aware, those of you who've been around this show for a long time, who've watched me do this from the beginning, people like Tyler, Bob Brewer, EHP Training, Marburger, and many others, probably Richard Kramer, you too, you probably know this. But when I first started the show, I set the time specifically at 9:30 Pacific time because that was literally right after the Ron Paul Liberty Report every day at 9 a.m. Pacific time. And for those of you who don't know, Ron Paul had an episode during his live stream on Friday. And I don't know what the right medical term is. Did he have a small stroke or something? But he was in the hospital the same day. And here he is. And I didn't see this morning's show, but I want to give a quick tip of the hat to a guy who I think is heroic to many of us who support the Constitution as a tool to advance liberty, because he's back doing live stream. I think of myself, sometimes I've got way too much on my plate. Here I'm still in my 40s, and sometimes I'm too tired or whatever it may be, and I'm like, man, I need a day off. And here's a guy who's in his 80s. He's in the hospital potentially for a stroke, a life-threatening situation, and there he is back to work on Monday, knocking out the message. So I just wanted to quick say that as well. It's pretty amazing. Blue North Wind said he did. He's recovering, and I'm shooting glad Ron Paul is back. Anyways, enough of that. Thank you all for being here. I hope you had a great weekend. Let's dive right into this and go through these 12 quotes from 4 Supreme Court justices that were nominated by President George Washington. And I think their views on liberty shows so much difference between then and today. And I want to start out with the first Chief Justice of the Supreme Court. That's John Jay. You may know him as one of the authors of the Federalist Papers, but he was a longtime revolutionary, a longtime slavery abolitionist as well. He served as the Chief Justice from 1789 to 1795. And the episode that Tom Woods and Kevin Gutzman did last week on the Supreme Court has some interesting history about how there wasn't a lot of cases at the time. So Jay actually went out of the country to negotiate a treaty, and some people who really supported him got him elected governor of New York while he was gone. So really interesting history. I encourage you to check that out. So here's the first quote that I want to go to. This is on property rights, and it was early on in 1774. Again, Jay was a longtime revolutionary supporter of the American Revolution. And in September of 1774, in a paper called An Address to the People of Great Britain, he put it this way: no power on earth, no power on earth has a right to take our property from us without our consent. Now, if we understand that many of the founders recognized property rights as foundational to all the others, James Madison, 1792-ish, maybe 1795, he wrote a great paper, a great article on property rights, pointing out how property is not just physical goods, but it's property in your own body, in your thoughts, in your views, in your speech, and the like. And this perspective from Jay is so different from any federal judge on any level today. No power on earth has a right to take our property from us without our consent. And here in the Federalist Papers, he didn't write all of them, clearly, but he was more prominent in the early ones. In Federalist number 4, this was in early 1788, I believe, he says, "It is too true, however disgraceful it may be to human nature, that nations in general will make war whenever they have a prospect of getting anything by it." He was recognizing, and so many of the other founders recognized, that the system created would not hurry the country into war because they knew that nations had a propensity to war. People with power wanted to enrich themselves through power and goods and money and the like, and they do that oftentimes through war. And he was talking about this in Federalist number 4. And then one of his actually opinions on the court, this was the only reported jury trial, at least that I'm aware of in the history of the Supreme Court. It's Georgia versus Brailsford, if I'm pronouncing that correctly. And he's supporting, in essence, jury nullification here. He says, "For as on the one hand, it is presumed that juries are the best judges of facts, it is on the other hand presumable that the court are the best judges of law. But still, both objects are lawfully within your power of decision." In other words, juries have a right and the power, and I think a duty, to judge not only the facts of the case and determine whether or not someone is guilty or not guilty based on the facts, but also on the justice of the law itself. If a law was passed without proper constitutional authority, then it is up to the jury to say, well, we're not going to convict someone for this. Thomas Jefferson basically took that position as an executive, saying, under his oath to the Constitution, if you're swearing an oath to the Constitution, it's your duty to make sure that you do everything possible to prevent the prosecution of people under an act of Congress or an act of the government that is not constitutional according to how you see it. And he was referring to the Alien and Sedition Acts of 1798. So here is John Jay, the first Chief Justice, opposing or recognizing that centralized power leads to war. It's a bad thing. He's in support of property rights. No one on earth has the power to take them without consent. And then, of course, here, jury nullification as well. The second justice that I want to mention is actually the third one to sit on the bench. He was the third seat, James Wilson. I've cited him many times on this show on a lot of different issues. He was one of the biggest big government guys of the time, but even these guys, and Jay was a big government guy in comparison to some of the others, the Patrick Henrys and others. But if we're talking about the big government people of then, in comparison to the big government people of now, basically all of them, it is night and day. And James Wilson was a tenther. Here's a big government guy who's very clear, pointing out in his famous State House speech, and I think Dave Benner said he was going to be working on an article covering this. There's a lot of juicy tidbits in this speech of October 1787 on the steps of the Philadelphia State House. He says, "Everything which is not given is reserved." In other words, look to the text of the document. Look to the Constitution itself. If it's not in there, then the federal government has no authority to be involved in that issue. James Wilson, 10th Amendment supporter in essence. Now, he wasn't in favor of having a Bill of Rights because he thought that would make things confusing. And if you guys are interested in that, I'd be happy to do a full overview episode of Wilson at some point in the future. Maybe I should do one on John Jay as well. But he served as the third seat on the bench from 1789 all the way to 1798. 10th Amendment supporter. Here he is in convention, June 16th, 1787. He points out that if the legislative authority be not restrained, there can be neither liberty nor stability. When we hear about stability with the federal system, most of the time, supporters of the monster state are talking about stability through the doctrine of stare decisis. That is, precedent is more important than the Constitution itself in many situations. For the lower courts, it's always more important. But for the Supreme Court, it is most of the time more important. They think stability means following erroneous decisions, following precedent, so you know what to expect. But really, the stability needs to come from the Constitution itself. And you can't have stability if the legislature can get involved in a bunch of stuff you never expected to get it involved in the first place. And that's really what James Wilson, another Supreme Court justice, had to say back in 1787. It has to have a very restrained power so you can have not only that stability, but liberty. Here's another one, October 28th, 1787. Also James Wilson. You're not going to hear too many people today, politicians, pundits, judges, justices, or anything, put it this way. He says, the citizens of the United States may always say, we reserve the right to do what we please. He's actually reaffirming the notion of sovereignty. And I've covered sovereignty in a number of episodes talking about the 10th Amendment and the foundation of the Constitution. Sovereignty in the American system is final authority. And Wilson, in his speeches over and over, like Madison, and on Friday's episode, I talked about Madison's views pretty extensively, but he was reaffirming the fact that no government is sovereign. It is the people of the several states who hold sovereignty. And it is not up to the government or any branch of the government to have final authority or final say on anything ever. It is up to the people. And that's really what James Wilson is saying here as well. We reserve the right to do what we please. Another one on sovereignty, December 1st, 1787. Again, James Wilson. He says, sovereignty resides in the people. They have not parted with it. Now, just because they delegate powers, and that was some of the confusion even at that time, and he was responding to that in this discussion here. He's basically saying, no government, the people haven't delegated any sovereignty away to state or federal governments. There is no final authority. The people who hold that final authority, we the people, the superior power of everyone, they've made the decision to delegate some authority to not only their state governments, but they're also delegating some authority to the federal government. And it is up to them how that is going to be divided. He says, sovereignty resides in the people. They have not parted with it. They have only dispensed such portions of power as were conceived necessary for the public welfare. The Constitution stands upon this broad principle. That is, we, the people of the several states, hold final authority, and it's only the federal government's job to do what's in that Constitution, what has been delegated to them in that Constitution by the sovereign people. That, again, was James Wilson, who was the third seat on the bench, 1789 to 1798. The third guy I want to talk about is Oliver Ellsworth. And he actually was nominated, he was the last one nominated to the Supreme Court by George Washington. He was actually the third Chief Justice. I think the second one was Rutledge, and then the third one is Oliver Ellsworth. He served from 1796 to 1800 and was from Connecticut. There was a lot of really good statements from him in the Connecticut Ratifying Convention. And here's one from January 7, 1788 that we post on our social media channels pretty regularly. We'll probably have that up later today as well. He says, if they make a law which the Constitution does not authorize, it is void. It's not void only after we're told it's void. It's void on its inception. And then it's the judge's job to say, like, we're not going to sanction this. That's what he's really saying there. If you're going to be on the court, the Supreme Court, their job is to say, we're not going to be on board with this. It is our oath to the Constitution to not say that this is okay in any case brought before us. But the idea that federal acts are supreme until we're told they're not to is absurd. That makes the Supreme Court have sovereignty, have final authority, when it's the people through their Constitution. And violations of the Constitution are violations of the Constitution, whether one branch of Congress passes something or another, or a president signs it, or a Supreme Court affirms it. Doesn't matter. The Constitution always reigns supreme. And Oliver Ellsworth really summed it up. It is void. And void is a great way to describe almost everything the federal government has done in our lifetime and for many decades before that. And it's really just time for the people to treat it that way too. And I'm going to get to that in a moment. Here's another one for Oliver Ellsworth. He says, this Constitution, this is about dividing the power between the federal and the state governments. Again, in that same ratifying convention, he says, this Constitution does not attempt to coerce sovereign bodies in their political capacity. No coercion is applicable to such bodies but that of an armed force. If we should attempt to execute the laws of the Union by sending an armed force against a delinquent state, it would involve the good and bad, the innocent and the guilty in the same calamity. In other words, it is not up to the federal government to be enforcing things on the states willy-nilly, which is really what happens today. He's not talking about incorporation because they weren't even thinking about the incorporation doctrine at that time. No one was even thinking of applying. I mean, of course, this was the ratifying debates in 1788, but he wasn't talking about that. But he was really opposing the idea of centralized power using force on the states, on the people of the several states. Here's another one. This goes to James Iredell. He was the 5th guy to serve on the court. Seat number 5. He wasn't in the first batch. They expanded the court, and he served from 1790 to 1799. And he's talking about factions here. We know that George Washington warned us about factions, but so did James Iredell. He said, most free countries, this is in the summer of 1788 in the North Carolina ratifying convention. He says, most free countries have lost their liberties by means of dissensions among themselves. If that isn't prophetic for today, I'm not sure what is. He says they are united in war and danger. Once there's a fear of a foreign danger, of course, people become united. James Madison warned us that that fear would lead to usurpations of authority, whether it's real or pretended. It ends up in the loss of liberty at home, but people tend to be more united in that time. But, he says, when peace and apparent security came, they split into factions and parties and thereby became a prey to foreign invaders. So the factions are dangerous to liberty. It's also dangerous to security to always be fighting amongst each other, the way we see happening now and all through history. That's James Iredell, who was the 5th Supreme Court Justice, July of 1788. Well, how do we deal with this? How do we deal with federal overreach? Iredell touched on this as well. Again, this is a federalist, kind of a big government supporter, especially in comparison to the Patrick Henrys of the day. And he points out that abuse may happen in any government. They recognize that power corrupts. We know that long-time maxim, power corrupts and absolute power corrupts absolutely. But everything in between is corrupting as well. Any level of power means that government is always liable to abuse. James Madison, of course, says government, the essence of government is power, and power being in human hands is always liable to abuse. And Iredell is telling us here, also in that ratifying convention in 1788 in North Carolina, he says abuse may happen in any government. The only resource against usurpation is the inherent right of the people to prevent its exercise. This is the case in all free governments in the world. The people will resist, Iredell said, if the government usurp powers not delegated to it. Usurpation is exercising of power not delegated to the government in the Constitution. St. George Tucker in 1803 pointed out that any usurpation is really treason against the sovereignty of the people. Now, mind you, everyone on the federal courts today takes the view that the judiciary is supreme. And usurpation is determined by the Supreme Court. But really, it's the people who are sovereign. The people have final authority, not the people, not the creature of the sovereigns, the sovereign people of the several states. So he's not saying the only recourse is to go sue in federal court and hope that the federal court will limit its own power, or the federal court will limit the federal Congress or the federal president. He's saying the only recourse, the only resource against usurpation is the inherent right of the people to resist it. And as long as there's always going to be some level of resistance to exercises of power not delegated to the government, then the government has a much more difficult time enforcing that. Now, James Madison, again, I keep citing James Madison as we're talking about this. because he's just making me think of things. In Federalist 46, around the same time, it was actually a little earlier than this. I'm not sure if they had crossed paths in this message, but it's certainly the same concept. In Federalist 46, Madison told us that the way to defeat federal programs, whether they are outside the bounds of the Constitution or just bad policy but still constitutional, is through a refusal to cooperate with officers of the Union. That is a form of resistance. Resistance isn't voting for one political party or the other. Resistance is actually resisting some. And here's a guy who sat on the bench till he died. He died young, but he sat on the bench till he died, and he took the position that the people would resist usurpations of power. Going further, here's what Iredell had to say, again, in that another speech. He gave a lot of speeches in the North Carolina Ratifying Convention. He says, if any future Congress should pass an act concerning the religion of the country, it would be an act which they are not authorized to pass by the Constitution and which the people would not obey. Again, this is taking a totally different approach than most people do today. Most people today take the view that when Congress passes something that they shouldn't pass, whether it's a gun control restriction or a health care mandate or whatever it may be, what the people are supposed to do is complain about it, vote the bums out, and then go through an expensive and long, something that takes a long time, a very time-consuming federal court lawsuit in the hopes that the federal courts will overturn this federal power. But that's not what Iredell was saying. Iredell, again, was saying the people would not obey it. Now, he's specifically talking about a law regarding religion, but you could apply that to really anything. When government usurps power, the people will not obey. People in general are only doing what the Supreme Court has sanctioned for them. Well, the Supreme Court, you got to wait for that lawsuit to go through. Don't start exercising your right to keep and bear arms until you get a permit. Don't do that. When they ban bump stocks, just sit tight on it. Just sit tight. Wait for this lawsuit to play out. Notice that is not what Iredell or any of these other leading founders and revolutionaries ever said. They never said wait on the federal courts or the federal government to somehow fix the problems created by itself. And here's how Iredell summed it up. He says, everyone would ask, who authorized the government to pass such an act? It is not warranted by the Constitution and is barefaced usurpation. Again, whenever they do something, that should be the first question we should always ask. Where is this authorized? And if they pass something that we don't believe is authorized, that I don't believe is authorized, that you don't believe is authorized, the solution is to resist it, not to wait on the federal government to fix its own problems. Now, Iredell is a guy that I think is possibly the best Supreme Court justice in history. He didn't serve a real long time, and there weren't a lot of cases back then. But I did an interesting overview, just kind of a quick overview, maybe about 15 minutes, 14 minutes, Forgotten Founder James Iredell last October, that I encourage you to check out that episode. I'm sure we'll share it on our social media channels, Facebook, Twitter, and elsewhere in the near future. But he was born on October 5th, 1751. So next week, we're going to be celebrating his birthday, and I'll probably send this out on social channels and maybe an email at that point. I encourage you to check it out. I will link to that in the show notes as well at 10thamendmentcenter.com/path to liberty. Taking a look over in the live chat, I hope you guys are noticing the stark difference in the viewpoints of these big government Supreme Court justices of the time. I mean, I guess none of them really are big government, but if we're grading on a curve in comparison to some of these so-called anti-federalists, these were the people who were supporting more consolidation of power versus less. And if they were the biggest big government people of the time, they're smaller government people than the smallest small government people in government today. Anyways, hopefully that makes sense. Quick hello to Bob Landry from San Antonio. Anna Rubio. Truth Free says, hola, looking to see if there's any questions. There's some back and forth. WC says, we need to remind the politicians of this, especially with mandates and shutdowns of healthy people. And really, whether you're talking about the state constitution being violated or the federal constitution being violated, I think some of these principles certainly do apply. When they do something that they're not authorized to do, the people should not be obeying them. the people should resist those things. Now, of course, there takes some strategy. You can't just go willy-nilly when we're talking about living under the largest government in the history of the world. There's some strategic thought that has to happen. Jefferson talked about that. Even in response to the Alien and Sedition Acts, the day after the Kentucky Resolutions of 1798 were passed, calling for a nullification of those, he sent James Madison a letter and said specifically, we don't want to push everything to extremities today. We have to affirm our overall principles, but we have to take a step. We don't want to push things to extremities. We want to push as far as events will render prudent. Seeing if there's anything else here, we must view the usurpations as treason against the people, and especially against individual, inherent, unalienable rights. Richard Kramer, it is good to see you, man. That was a great quote. Absolutely. And that's how St. George Tucker put it. This isn't the same type of treason as listed in the Constitution. It is treason against the sovereignty of the people. And the people, as long as they continue complying, will see more and more and more of it over time. Well, I hope you guys found this interesting. I hope you learned something. This isn't as deep of a dive as I've done on some Supreme Court things in the past week, but I thought these quotes and maybe pointing out some of these names would encourage you to read and learn a little bit more. Of course, I will include all of this information in the original source documents in the show notes at 10thamendmentcenter.com/path-to-liberty. If you like this information, if you like the show, you support what we're doing at the TAC, you can do a number of free things really easy to help us spread the word. That's smash the like button, subscribe, reviews on iTunes or other podcast platforms all help out. You can also support us financially. A bunch of you out there already who are members, and I'm so grateful for your support. Please do not feel obligated to join us as a member or to make any financial contribution, because we're going to continue doing this work and providing this information for free to as many people as we can reach. But those of you who join us and pitch in as little as $2 a month, you help us reach new people every single day. You can join us over at 10thamendmentcenter.com/members. If you've got any questions, make sure to leave them in the comments. I will read them a little bit later today, or feel free to email me at team@10thamendmentcenter.com. I read through everything. I don't get a chance to reply to everything, but I do get a lot of great ideas for future episodes as well from your feedback. I really hope you enjoyed this episode as much as I enjoyed sharing this information with you. I hope you had a great weekend. Your Monday is off to a good start, and I'll see you next time here on the Path to Liberty.